facts. So thank you so much for sharing those with us. And now, taking that knowledge, we'll move into the second portion of the webinar, which is hearing from our legal experts who are leading some of the most critical cases right now that are getting people out of detention and really taking a step forward in terms of human rights in our country. So here's the lineup. We have Eunice Cho, who's the senior staff attorney at the ACLU National Prison Project, and her work focuses on challenging unconstitutional conditions in U.S. immigration detention facilities, as well as the expansion of immigration detention. And she's leading ACLU's litigation response to COVID-19 immigration detention at the moment, and recently co-authored a report entitled Justice-Free Zones, Immigration Detention Under the Trump Administration, which we definitely recommend reading. It tracks the expansion and worsening of conditions of immigration detention under this administration. After we hear from Eunice, we will also hear from Lisa Graybill and Maia Fleischman, who are the Deputy Legal Director and the Law Fellow, respectively, at the Southern Poverty Law Center, as well as Elizabeth Jordan, who is the Director of the Immigration Detention Accountability Project and the Civil Rights Education and Enforcement Center. And all three of those panelists, Lisa, Maia, and Elizabeth, are all counsel in Fraihat versus ICE. Then we'll hear from Neha Desai, who is the Director for Immigration at the National Center for Youth Law, who is counsel in Flores versus Barr. And finally, we will hear from Gregory Copeland, the legal director, and Sarah Gillman, legal director at the Rapid Defense Network. And they are counsel in O.M.G. et al. Versus Wolf, and a number of other cases. So with that, I will turn it over to Ian to moderate the second half of our webinar.
Thanks so much, Catherine, and all. It's really fabulous to have these wonderful legal minds together to share for those with family and loved ones in detention some of the developments from the legal cases. And what I thought we would do is start with a discussion with Eunice about the work of the ACLU, and perhaps you can provide us a little bit broader sense of the landscape, and then we can drill down and hear a bit more specifically about some of these other important cases, and then go to a Q&A. So Eunice, would you like to start us off by sharing a little bit about how lawyers are fighting to get people out of detention and improve conditions, and sort of what's the record, or what's the state of the success that they've had so far?
Sure. Well, I just wanted to say thank you to Cornell and PHR for organizing this panel, and it's really exciting to be part of this conversation. So many of the folks on the medical end have been incredibly helpful in terms of supporting the litigation with expert declarations and providing information about the health risks that come up in detention, and also really exciting to talk with folks who have been litigating these issues around the country, because it is, given ICE's resistance to releasing people on a wide scale, it is taking an all hands on deck approach to get as many people out as quickly as possible. We first launched, at the ACLU, launched litigation around COVID-19 and immigration detention in March 2020 as local governments and then the federal government began to issue shelter-in-place orders related to COVID-19. It's not that long ago, but of course it feels like a lifetime ago in another sense. And I think the inspiration for the litigation really came up actually when reading an ICE press release in early March when COVID started to hit. And so at that point, I know that many of us in the prison and jails world, advocacy world, and in detention world were thinking about what we knew was going to be a terrible disaster when COVID hit in those facilities. And there was also, I think, some brewing thinking about how to prepare things like parole materials for parole petitions for detainees. And I remember reading the ICE press statement at the time, and it said, ICE only has authority to detain individuals for immigration purposes. ICE cannot hold any detainee ordered released by a judge. And at that point, it became very clear that litigation to release people was going to be necessary. So a week later, we filed our first case challenging the detention of medically vulnerable people in ICE detention in the Western District of Washington in late March 2016. And because Seattle was the first hotspot for COVID in the country. And since then, we have seen a wave of litigation around the country requesting the release of immigrant detainees due to COVID-19. And, we've been proud to just see, how this has resulted in the release of people and the establishment of very good case law with respect to how this violates Fifth Amendment due process rights for detainees and how courts have the authority to release people on the basis of dangerous conditions in detention facilities. And, this has been, I have to emphasize that this has been in response and in support of the broader movement of detainees and families, advocates, and organizers who are all fighting for the release of people from detention. And I also want to point out that this work has an analog in the prison and jail context, right? Because there are clear parallels between the work happening in immigration detention and those our allies working in the mass incarceration context in terms of the fight to free people from prison and jail in the context of COVID-19 as well. The litigation strategy is really premised on the argument that the government has the duty to keep people in their custody safe under the Fifth Amendment's due process clause for immigrant detainees. And this includes safety from serious illness and death from communicable diseases like COVID-19. And so our strategy has been premised on the need to release the maximum number of people possible from detention in the quickest time possible, given what we know about the spread of COVID-19, especially in circumstances like detention. And our public health experts advise that people who are medically vulnerable, who are most seriously at risk to serious illness and death from COVID-19, should be among those who are released first. And so while we also know that facilities must do what they have to do to improve cleanliness, provide soap, hand sanitizer, make sure that there's social distancing, we really believe that the most important thing to do is to release people from detention quickly, especially those who have a high likelihood of death. Thus far, the ACLU, we have filed over 51 cases nationwide, including 10 class action suits. My son is about to join me. Litigation brought by the ACLU and its affiliates. We've been responsible for about 420 people being released as a result of court orders or ICE discretion. And we know that many other cases around the country have also resulted in the release of people. At this point, the number of people detained by ICE is actually at the lowest point in over a decade. This is, of course, we cannot take credit for this reduction in numbers. It's also largely in part due to the shutdown at the border. The failure to admit new people to immigration, ICE custody at all. But it is helpful to look at the numbers in terms of the fact that the Trump administration last year detained an all-time high of about 56,000 people in detention. And as of May 23rd, 2020, the detained population is around 26,000 people. So substantially less than, much more than half number of reduction. We have a number of class actions pending, and I know there's others in the country that directly request the release of many more people from detention. So we hope that we can help to secure the release of many more people from detention in the near future.
Great, thanks. And one of the things, because of the goal of providing information to families and loved ones, as well as sponsors might be receiving folks from detention, would be to hear a little bit about what can families or loved ones share with those in detention or can be doing on the outside to support litigation or to contribute to this movement?
Well, I mean, that's a great question. I think part of the question is also what can our litigation do to support families and people on the inside? Really, that is the mode and the reason for this work. But in terms of just trying to kind of help ease and help the process in terms of identifying people who should be released from detention quickly and gathering the information that's needed. I think it is always very helpful, especially in light of the enhanced barriers to communication with people in detention. ICE has used the COVID-19 crisis and justifiably, to help stop the spread of people, limiting the number of people who can come into the facility, but it has also made it much more difficult for attorneys to communicate with clients in detention and have access to people in detention. So having contacts on the outside who can serve as a third party, who can, provide important information necessary for litigation, including medical information, records, identifying release strategies. If detainees have a family member or community members with whom they can be released to safely outside, that's important. We also really want detainees to be able to document the conditions so we can put that information in declarations. How is it that you're not able to protect yourself in detention? Are there people who are sick and have wanted tests, but that, can't get them? Are there people being transferred into the facilities? Are guards and other people wearing masks and protective equipment? Is it possible to actually, socially distance and practice good hygiene in detention? I think those are really important. That's important information that's critical for courts to know about. And, if detainees can identify that information is very helpful. I think the other thing is, connecting with local organizing groups and immigration lawyers and advocacy groups who are working to push and amplify and build resistance to what's happening in these detention centers is incredibly important. And I think, of course, being in touch, that's very, very hard right now. But I think trying to maintain, to the extent possible, lines of communication is incredibly important right now.
Thanks so much. And it's a question we'll hear about from the other litigators as well. And we'll move on now and come back in the Q&A to some of these topics, but move on to the next group of speakers, well represented, and we're grateful for the team joining. And that's Lisa, Maia, and Liz, who will tell us a little bit about the Fraihat case. So what I'd love to hear from is similar sorts of questions. What is your case and work seek to do? What's the status, and how have things developed so far? And then we can circle back, but would love to hear more about who's helped and how folks on this call or who have loved ones on the inside can contribute to these efforts.
Sure. This is Lisa Graybill from SPLC, and I'm going to start, and then our co-counsel Liz Jordan will speak, and so will Maia Fleischman. So very quickly, we're counsel in a case called Fraihat versus ICE, which was filed well before COVID was on anyone's radar back in August of 2020, to challenge what we all know to be the abominable medical and mental health care conditions across ICE's system of facilities. Specifically, we challenge the inadequacy of medical and mental health care treatment, the abusive and excessive use of solitary confinement, and discrimination on the basis of disability on behalf of a putative class of all the immigrants detained at the approximately 158 different detention facilities that sprinkle across the country, whether they're run by ICE directly or run by, whether they're a local jail working in contract with ICE or run by one of the private prison providers. As far as we know, no one had tried to sort of bring an overall case against ICE before to say, your failure to adequately implement and ensure standards are enforced in your facilities results in a substantial risk of harm to everybody who's in detention, because you have no mechanism for ensuring that proper care is consistently available and the detainees have access to it. We did point out in our pleading that ICE, this is not optional. The Constitution and federal statutes require this, and but in comparison, ICE is certainly not required to detain all the people that it does. And our argument is basically that if ICE is going to try to detain this many people, it has to provide them adequate conditions. And of course, our hope is that ICE will choose simply to detain fewer people, and we're trying to put a squeeze on the system that way. It was filed in August of 2019 in the Central District of California in Riverside, but it is a nationwide or systemic case. And we have 15 named plaintiffs at 8 different detention facilities. We filed it with the intention of impacting the way ICE manages medical care, mental health care, solitary, and disability across all facilities in the country. With that, I'll turn it to Liz.
Thanks, Lisa. And I think that background is really important to what we're about to say with regards to coronavirus. Because as Lisa mentioned, and as some of the doctors mentioned on the first panel, we're starting from a place where ICE can't handle routine medical care. They can't handle medical emergencies of other sorts. We've seen rolling outbreaks of chicken pox and measles and mumps in the detention centers. And so, nobody was inclined to give ICE the benefit of the doubt that they would be doing it right. when it comes to this pandemic. So, bearing in mind the fact that we'd already alleged all of these problems in ICE detention, and we had a set of class representatives who were vulnerable to serious complication or death if they caught coronavirus because of the underlying medical conditions some of them had that we were already complaining about. In March, we decided to see if we could take some emergency steps in our existing litigation to try to force a systemic response from ICE to the pandemic that was clearly sort of bearing down on people in detention, and sort of trying to carve out a spot to talk about the systems to leave room for folks like Eunice and the other litigators who were litigating more individual cases or more facility-specific cases. We think that our case is a complement to that. So in early April, we filed asking our same judge in Riverside to please certify a class, sorry, actually 2 classes of people who are medically vulnerable either on a constitutional basis because of the unacceptable risk of harm under the 5th Amendment that Eunice mentioned, or that they were discriminated against by being placed at such risk, which is illegal under Section 504 of the Rehab Act, which protects people with disabilities, and issue some emergency injunctive orders to force ICE to try to clean up its act. So on April 20th, the judge ruled in favor. So he certified both of those classes, and Maia in just a second will show you some more detail on where to find the language of the orders. And then he also issued a preliminary injunction requiring ICE to do 3 things. The first is to properly identify everybody in their custody who has a risk factor. And notably, the judge bought our argument that there are certain risk factors in detention that are different than risk factors in the general population. So for example, our age for advanced age is 55, where the CDC recommendation is 65. Our judge also included psychiatric illness as a risk factor, which the CDC, I think, still has not spoken to, but studies are increasingly showing that that is a risk factor. And we also know that ICE, because of their poor record keeping, because of their poor, their understaffing and their inappropriate use of lower level medical professionals and those sorts of things, they miss a lot of people's diagnoses. And so, the first step in this order is to really properly sort out who has a risk factor. The second step, according to our judge, is that ICE, through its own administrative review process, once it has identified somebody, needs to consider whether continued detention of that person is appropriate. Calling that a custody redetermination review under Fraihat, and we have, been recommending to people that they affirmatively request that to ICE, which we'll talk about a little bit more in just a second as well. And the reason for that is because, we also argue that the public health consensus is the safest place for somebody in this pandemic is to be sheltering at home in community, not left in the detention center. And so release is the mechanism, obviously to accomplish that. However, our judge has also taken sort of a third step, which is that, we recognize that ICE is not going to open their doors to everybody super willingly and let everybody out. And so the judge has issued orders regarding the conditions in the detention centers for people who remain detained in ways to try to mitigate their risk of harm while they're in the detention center. So that's what he ordered. I'm going to very briefly say where we are right now, and then I want to give Maia plenty of time to share with folks sort of concrete ways to get their loved ones involved or get them help. So this order came down on April 20th. ICE has been extremely recalcitrant. I would argue being a bad actor. They have taken the absolute minimum approach to all of this. And so we have also already subsequently filed and received an order from the judge ordering that they begin to provide us with information so that we can properly monitor and ensure compliance with the order. In that follow-up order, the judge noted that they were being lackadaisical in their systemic response to coronavirus. They continue to be lackadaisical at this point. And we are figuring out ways to raise ongoing issues with opposing counsel and then potentially back with the court in the very near future. So with that, I'll turn it over to Maia.
Hey everyone, my name is Maia Fleischman. I'm a law fellow with the Southern Poverty Law Center. Can you all see a screen that says Fraihat ICE Community Resources? Great. So like Liz mentioned, although ICE has the burden to follow the order and start evaluating people to release, there's a lot of issues wrong with their whole system when it comes to medical care. So we're encouraging people to file their own Fraihat requests. And there's 3 ways to do that. One being that pro bono attorneys can do it, or their existing immigration attorneys, any really attorney can do that. And we think that's a very effective way for, for ICE to reconsider their request for release. So if we have a toolkit on our SPLC website, and I will drop that link in the chat after I'm done speaking. But here you'll find a bunch of resources that I'll just quickly go through. So like I said, one of the ways that we are encouraging people to file reconsideration requests on behalf of folks detained in ICE custody is by submitting a client letter, a custody redetermination letter. So we have a template that we posted. And basically a lot of the word is already in there. The wording's already in there. If you have medical records, great. If not, we're still encouraging people to submit the letters. So that's one way that we've been encouraging. And through the Creek, Creek set up a pro bono volunteer with the action. So if you're interested in volunteering, SPLC, Creek, and Disability Rights Advocates, who's our co-counsel as well, have been hosting trainings once a week for our pro bono attorneys, and everyone is set up with a mentor that helps them through the process. So that is one way that we are encouraging people to submit Fraihat reconsideration requests. And after people submit the Fraihat reconsideration request, we ask that you email us, and I'll drop the email address that we set up. And that's how we are ensuring that the court is following, that ICE is following the court's order. So really our primary purpose is to, as Eunice said, just get as many folks released as possible from ICE custody. And then, secondary to that is that we're also gathering evidence on how much ICE is actually complying with the court's order. So based on a lot of the evidence that folks have been submitting to us, we've been bringing it back to the court and saying that, where ICE is really failing to comply with the court's order, specifically by field office, because some field offices are worse actors than others. A second way that people can help is that their sponsors can also submit a release request pursuant to Fraihat. So here we have like a step-by-step instruction and how to submit, and we're actually just got that translated into Spanish and will be posted on our website. And then lastly, we have for people to submit pro se release requests. This is a little bit more challenging. What some people have been doing is, for example, here in Florida, like the detention groups have been mailing copies of these requests. So, folks that are detained can go ahead and submit one in the box that they have in their dorm that's labeled ICE. However, what we prefer is for people on the outside to submit requests, because we believe that ICE is more likely to actually look at them. We know from a lot of people from the inside that ICE rarely checks the box with the requests. You'll also find on our website the preliminary injunction and the subclass certification order, so you can go ahead and see if your client or your friends or your family maybe falls under one of these risk factors. And lastly, we also have key quotes from the judge's decision posted, and frequently asked questions, resources like that. And we have a notice to court order. We have that translated into 10 languages total. We're adding a couple more right now. but those will be posted in detention facilities all over the country soon. We're also setting up, so that notifies people whether or not they're potential class members or they're class members, and they deserve, or they are entitled to a custody redetermination request by ICE. And lastly, we are in the process of working with ICE to set up a hotline so our class members can call us for free. We have people working the hotline every day to respond to our class members and help them through the process. I don't know if I left anything out, but I will be dropping resources in the chat. So if you're interested in volunteering, or if you know family, friends that are interested in submitting Fraihat redetermination requests, that you can look into it. Thank you.
Thanks so much. Now we'll move on to hear from Neha about the Flores v. Barr case.
Great, thanks, Ian. I'm gonna actually start, I'm gonna share my screen and just share a few slides here. So give me one moment. Is everybody able to see this?
Yes.
Okay, great. So I'm going to start by backing up a little bit, since Flores is a case that spans decades and decades and was not filed recently in the context of COVID, but of course our most recent active litigation has been focused on COVID. The population of kids that I'm going to be speaking about right now are children that are unaccompanied. The Flores settlement agreement, actually, I'm sorry, I'm going to start with this slide to share a little bit about the Flores settlement overall. So this case was actually filed back in 1985 when a child named Jenny Flores and a number of other children were found in a kind of makeshift detention center that the government had set up, commingling children and adults, absolutely no education, no child-specific provisions or accommodations whatsoever, no accountability. And the case was filed to really challenge the procedures around detention, treatment, and release of immigrant children, all immigrant children, and I'll break that down in a moment. So this was actively litigated up and down the circuit courts, up to the Supreme Court, and settled in 1997 with the settlement agreement that we are currently still living with and actively litigating. At this point, it is the only real mechanism that allows for regular oversight, access to children in detention facilities, the ability to interview them and ensure that the government is complying with the provisions that they agreed to back in 1997. So I've listed here a couple of the different protections that are born in the settlement agreement. But for purposes of our conversation today, I mean, what is most important is really the thrust of this agreement is that children are released as expeditiously as possible. So they get out of custody quickly, but while they're in custody, they're treated appropriately. They're in safe and sanitary conditions. They are in facilities that meet their needs. About 5 or 6 years ago, there was very active litigation where the government was challenging essentially who this settlement applies to, because when it was originally drafted, there was a very different population of children in federal immigration custody than there has been over the past few decades. And the government wanted to take the position that really this settlement only applies to unaccompanied children. So unaccompanied children are the population of children that arrive at the border under the age of 18 without a parent or legal guardian, and ultimately get transferred into the custody of the Office of Refugee Resettlement. So they are under the custody of Health and Human Services. Now there's also a population of children that come with their families, and they come through, all children first come through Customs and Border Patrol, but accompanied children often get transferred with their family members into ICE facilities. So thus far, the litigation that's been discussed is really focused on children in ICE and adults in ICE facilities. But I will be focusing a bit more on the children that are unaccompanied and that are in the custody of the Office of Refugee Resettlement. So one thing that I wanted to mention as well before I get in too far is that there are kind of several bodies of law that really govern the rights around unaccompanied children. So one is the settlement agreement that I'm talking about right now. The Trafficking Victims Protection Reauthorization Act is another really critical body of law that speaks to what unaccompanied children are entitled to. And then, of course, the Constitution is kind of the framework that governs all of this. But in the context of litigating Flores, we are really only able to address, as our judge likes to put it, the four corners of the settlement agreement. So we're not able to make broader legal arguments about the rights of our class members outside of the Flores settlement agreement. So we have actually also filed separate litigation that I won't be getting into in detail today, but litigation that kind of expands the body of law protecting these children. So once children are transferred to ORR facilities, and there are over 100 facilities spread throughout the country, and there's a range of the type of facilities that children are held in. They're at the least restrictive level. There are actually facilities that are essentially like foster homes, and then there are more restrictive facilities. There are several levels of increasingly restrictive facilities. Some of them are residential treatment facilities that serve children with special needs, and then there are staff secure and secure facilities, which are just juvenile detention centers. So there's quite a range, and the treatment that children experience varies broadly depending on where they are. So there have been, as I mentioned, kind of a number of different challenges within the Flores litigation over the past several years, but kind of getting to where we are currently with the litigation around COVID, in March, or kind of early to mid-March, we started hearing a lot of reports in New York in particular, where of course things were really hitting a crisis level proportion. So the children that are detained in facilities in New York, we were hearing from lawyers there telling us that they were very concerned about the lack of measures that OR was taking within the facilities to ensure that children were not being exposed. The fact that there were, at that point, even in early March, several confirmed cases of staff who had tested positive, and yet they were not being quarantined, children were not being quarantined. But moreover, and Dr. Shapiro mentioned this earlier, the larger issue that there were many kids in custody, not just in New York, but certainly there and elsewhere, who did not need to be there. So children that are unaccompanied are generally in some stage of the process of having the government determine whether they can be released to a sponsor. So historically, the majority of these children had family to whom they could be released, and the government has taken, at times, has taken 20, 30 days to go through the process of evaluating how long, of whether a sponsor is appropriate, but then over the past year, we've seen that number increase to almost 60, 70, 80 days before, on average, they are releasing children. So we were hearing of more and more children that could be released, but were not being released, and very conflicting information about whether COVID was actually a basis for not releasing, because some facilities were taking the position that if a staff member had tested positive, that they couldn't release the children, whereas our medical experts who provided declarations in the TRO that we filed testified just the opposite, that there were many safe ways to have children released even in facilities where staff had tested positive, and in fact it was much safer overall for everyone's benefit for these children to be released. So we filed litigation back in March 26th, and we've had 4 different hearings before the judge. Now, the litigation impacts both accompanied children and unaccompanied children, but since we have attorneys from O.M.G. speaking particularly about children in the family residential centers, I will leave that portion to them. When we first filed, there were no confirmed cases of children who had tested positive, but a number of staff that had tested positive in various facilities. And the judge in the initial hearing felt like that we had raised a number of issues demonstrating that the government was not releasing kids promptly and not complying, particularly on the ICE side, with their obligations to keep children and families in safe conditions. So she initially ordered a number of, she asked the government to produce data, individualized data for every single child in custody. And just in terms of numbers, I should say, you know, and others have mentioned that the numbers of kids in custody have dropped dramatically, both because of the border closures, but even before that, there were a number of measures being taken to restrict children from entering. So whereas almost a year and a half ago, there was as many as 14,000 children in OR custody. At this point, there's only about 1,500. Of those, about 900 are in congregate care facilities. So one of the positions that we were taking in our litigation was, well, of course, first and foremost, children should be released expeditiously, but when they can't be released, children should be moved from congregate care facilities to the more individualized foster homes that I had mentioned earlier on. And that would further reduce the population so that social distancing and other measures could be taken in congregate care facilities. Just to speed ahead, because we've been through a number of different rounds with this litigation, kind of where we are now. I'm sorry, actually, Ian, would you like me to pause there and ask a follow-up question, or do you want me to jump to kind of where we are now?
No, it'd be great to hear sort of where we are now, and then we'll hear from the last panelist, and we can open up to a broader discussion among everyone. So that's
okay, perfect. Thank you. All right, so where we are now, in her final order, which was on May 22nd, she found that the government was continuing to fail to comply. I think Liz had mentioned their lackadaisical and kind of recalcitrant approach, particularly on the ICE side, and that is absolutely the case. ICE is continuing to detain accompanied children that should be released. On the ORR side, the government has found that, the judge has found that the government is providing the data adequately that she requested in terms of individualized determinations as to why children are still there, why they haven't been released to their sponsors, but she continued to express frustration that they were failing to comply with her order, which her prior order had ordered the provisional release of certain categories of children. And in the report that the juvenile coordinator submitted pursuant to her prior order, they admitted that they had not provisionally released any children. So I think Dr. Shapiro mentioned earlier on the situation around kids that were aging out of ICE ORR custody into ICE custody, and this is something that is of grave concern to us. And there was one particular youth who was a client of a legal service provider based in Chicago, and that client had a child that was going to age out 4 days later after our hearing when we submitted this declaration, and that child fell into the prior order and should have been provisionally released but was not. And so the judge during our last hearing ordered that child be provisionally released. And that's the first time she's really taken that step. She also continued to require certain pieces of data that the government must produce, but really stressed that that ICE can't provide this meaningless data that they have been for the past several months, and that they first have to meet with the special monitor and ensure that the individualized information they're providing as to why each child who's in the family residential centers continues to be there is particularized and is not just generic information on which she can't really make a determination about compliance or lack thereof. She also increased the monitoring efforts that Dr. Paul Weiss and the special monitor, Andrea Sheridan-Orden, have so that they can really investigate what's happening in the family residential centers. She also required that the parties meet and confer in June around how families in family residential centers are being advised of their rights. And she acknowledged the extraordinary unnecessary emotional turmoil that was inflicted on families as ICE allegedly tried to comply this last round over the past few weeks. So we have a status conference coming up again in June, on June 19th, and she indicated that we would continue to have status conferences essentially throughout the pandemic to ensure compliance. So I will pause there and happy to answer questions later.
Great, thanks so much. And we'll move on now to hear from Sarah and Gregory, who are counsel with co-counsel in the O.M.G litigation, but also counsel in other important litigation in this area as well. And the same questions, Sarah and Gregory, and Neha, you can stop sharing your screen when you get a chance. That tell us a little bit about what your litigation is trying to do and what the status is, and how those on the phone who might have loved ones in detention could be helped, or what they could do to support your important work.
So I'll give a brief overview to begin with. So Sarah and I run a small organization outside of area in New York City. We do federal litigation nationwide. During the COVID pandemic, we've sought to sort of, just accelerate what we typically do, which is partner with community organizations, people that are directly impacted by ICE's conduct, and sort of build a litigation team around that, exploiting all the sort of resources that everyone else is talking about. A lot of the first panel have helped us out, including, Dr. Shapiro, Dr. Keitzel, we've used some of your other declarations, and so we really appreciate that. But so RDN's approach has generally been to rapidly respond to whatever we're seeing ICE doing in an inclusive manner that allows us to level the playing field, including as broad of a group of the different populations that we've been able to work on behalf of during the crisis. So, we filed 4 big cases during the crisis, including the O.M.G case, which is on behalf of all families and family residential centers. This is one of the first and big cases filed during the crisis, in between the ACLU's case and the Flores filing. The O.M.G case was filed, and so that was on behalf of approximately 1,400 families or family members that were detained at the 3 family residential centers, ICE, baby jails, 2 in Texas and 1 in Pennsylvania. So that was the O.M.G case, and then subsequently we've also filed cases on behalf of all ICE detainees in the 3 detention facilities under the under the new Miami field office, which is approximately, I think, 1,400 adult detainees. We've also filed a case on behalf of all transgender detainees. I think I got a dog in the background, but so we filed that was on behalf of all transgender detainees in ICE detention across the country. Unfortunately, we got a bad decision on our TRO and our class certification 2 days ago. And then finally, which I think could be a case that sort of expands from here, is we filed a case on behalf of approximately 200 plus mothers and children that are detained in Dilley Family Residential Center or Southern Texas Residential Center, Dilley, and the Berks Residential Family Detention Center. And that case seeks to prevent removal, given the fact that the removal process is so unsafe. The removal process involves a number of sort of the vectors that we've discussed here as being vulnerabilities, transfers. It's got, diverse groups of people coming from all around being grouped together in close proximity. So, while the whole detention system is deadly, and in our view deadly, not just if you have an underlying condition, it's sufficiently life-threatening that no one should be exposed to this, regardless if you have a high risk of dying or not. Such that that was our such that the final effort in ICE's efforts to remove people, deportation, can be sort of the most deadly and the weakest. Any weak link in these chains exposes people to harm, such that we've successfully prevented the deportation of these 200 plus mothers and children for this period of time, because the process is not established to be sufficiently safe. I'll let Sarah go into sort of the details of our cases in the first instance. You're on mute, Sarah.
Sorry, guys. Hi, everyone. So as Gregory said, we filed the O.M.G case very early on. We actually filed it March 21st, and it sought the release of all families in these 3 detention centers. We initially got an order from the court that said the parents, so their families in detention, so some of the children, or all the children are covered by Flores, but the parents were not protected by that. And so that the parents essentially had the same rights as the children, you know, in this situation. Since that order was enacted, the government's had to file a number of different updates to the court. I think the litigation has proceeded, like many of these cases around the country, where the government comes in and says everything's fine. The amazing clients and advocates on the ground have done an amazing job of sort of amassing the evidence to go back to the court and say, no, not everything is fine. And the court in O.M.G is very much tracking the timeline of Flores. So I know Counsel for Flores just previously stated that they have another status updater hearing on June 19th. And I believe that our next report is due on, or the government's next status report is due on June 19th. So the judge is very much tracking what's going on in Flores. And then we have another status conference on June 26th. Most recently, the government took a pretty aggressive approach, or I guess pretty standard approach for them, to move to dismiss the lawsuit, incredibly relying on the evidence that they have amassed since our lawsuit was filed. So we're going to be, you know, defending that. You know, as a result of the lawsuit, we have had people released from detention, which has been a positive. And I think that also, you know, it has brought, I think the lawsuit has brought to light the situation for people in family detention. You know, Dr. Shapiro, who has graciously donated his time to that case, and also the case that Gregory mentioned, where we seek the stay of deportation of families in Dilley, has been working, you know, with a group of other doctors for a very long time to highlight the already pretty, you know, terrible conditions for families in these centers. And so we, you know, we hope that through this lawsuit, it gives a voice to those who, you know, are continuing to be detained in these centers. And hopefully, as the litigation goes on, we hope that more people will be released. I think that, you know, in thinking about who we have helped, which I know is one of the questions, I think Gregory can talk to that a little bit, and then I'll just briefly say what I think we can, what can be done to further support what families can do and what the community can do.
So what did you want me to cover, sir? Sorry.
Okay, I think I actually covered. I said who can be helped. I think it's the families who are in the 3 directed.
Yeah, I mean, look. Our goal is our goal of all of our litigation is to help anybody that's in ICE detention. So what should families do? You know, families should keep pushing to get, you know, their family members out. I mean, this whole process over the last 2 months has been really demoralizing, that there wasn't sort of a broad consensus effort to reduce the prison populations, you know, sensibly across the board. But, you know, I think you should be a squeaky wheel. You should not sort of, you know, I think the success we've seen in these litigation efforts, you know, a lot of the success that, you know, from my view, has been finding ways of building upon cases that already existed and sort of, you know, modifying them and using the COVID crisis as a way of, you know, magnifying an issue that already existed. I mean, Flores existed before, Fraihat existed before, you know, one of our only directly successful cases was, you know, pre-existing just Zedvitas prolonged detention habeas case. So, you know, I think that there's a lot of need for people to push for this work. There should be there's a huge demand for it that there's not the need to meet. And that's really disturbing, I think, for everybody on this call, whether it's like because there's not enough people to be doing this work or because there's not enough people to help out your family members. But I think people need to keep pushing this stuff. I mean, the idea that it's justified for the government to expose people to, you know, a deadly virus on the basis of a civil violation is absurd. Sadly, like we haven't been as successful in our litigation efforts as we have been, but like Fraihat's telling you, keep records, keep the evidence. Like that's helpful no matter what, however you attack this. But yeah, I would I think that everyone just needs to keep pushing. We keep losing, we win. We keep losing, we win. And we just need to keep, unfortunately, keep at it.
I was just going to add, for the community, I think it's really important. I think that COVID-19, as we're all talking about, just further highlighted the problems that have existed for a very, very long time in detention. And often people in detention, as we all know, who are, listening or participating in this webinar, just have been I don't want to say ignored, but their voices are not heard, I think, as much on a continuous basis. And I have been very encouraged by the outpouring of the medical community in particular in really banding together and adding the critical evidence that we need to be able to present this case. And I think it's, a time when you can think about changing the narrative, or all of us changing the narrative and helping to say that it's not only when COVID-19 is hitting this community, it's always, like, the people in detention always need to be represented. There's tons of issues that lawyers can certainly continue to litigate, but we also need, like, the community support, as Gregory was talking about, and for families to keep pushing to highlight this. And and particularly in O.M.G, I just even putting together that case and looking at the work that Dr. Shapiro and his colleagues had done, starting back, I think, in 2014 or 15, Drs. Allen and Dr. Rich. So that would be my endpoint on that.
Great, thanks so much. Before we open it to a broader Q&A, I just wanted to see if any of the panelists from the sort of second segment on the litigation matters wanted to jump back in to comment on anything colleagues have shared. And we'll give a minute or two for that, and then my colleague Gabby will lead us in our Q&A more broadly. So anything from the other litigation teams or further reflections before we shift even more broadly? Great. Well, we can certainly continue to reflect on this in our broader Q&A. But Gabriela, if you'd like to lead us now in a broader discussion, we've got about 16 minutes before the webinar will end, and folks can share questions in the chat. And thanks so much, everyone, for this discussion. We'll open it up, and feel free to pose questions that both implicate the litigators from the second part of the discussion or the medical experts from the first portion.
Thank you, Ian. So currently nobody has sent me any questions through the chat, but I do have the list of questions from the registration. And so we'll start with those. So somebody asked, have there been any COVID-19 related updates to the public charge rule? So I'm not sure if any of you feel particularly ready to speak to that. So I'll just open it up. Nope. All right. We also have a question about obtaining medical records from the detention facility. Somebody asked about, what is an efficient way to obtain a client's medical records? I've seen different policies and procedures depending on the facility or the deportation officer. Not sure if anybody has an answer for that.
This is Liz. I can take that quickly. The answer is it's all over the place. It really varies quite widely. Most places need some sort of signed written release, but who you direct that to and whether they want it on their own, like, company proprietary form, how long they take to get back to you, and whether they are particularly responsive is totally all over the place. So unfortunately, it's a massive mess trying to get medical records, and I don't have any silver bullets to offer.
Yeah, it is. I mean,
oh, sorry.
Go ahead.
No, I just wanted to add that having seen some medical records that have been obtained, they're very, there are chunks missing. The quality of reporting and documentation is very poor at times. So even having them doesn't mean that you're going to get some good details there.
Yeah, I mean, I would echo that. I think that it is going to be detention center specific. I think that to the degree that you can, you can keep submitting the wrong form, to the degree that you can put it on ice to tell you what you actually have to do, either as a fact point to prove in litigation later on, or as, actually on the path to resolving getting your medical records. But I think that it's difficult for all the reasons that have been echoed in different ways on this call.
Thank you guys for those answers. I did just receive a question in the chat, and somebody is asking, they say, we focused on ICE and ORR. Is there anything more, litigation or otherwise, related to CBP, U.S. Marshals, or BOP that panelists can share?
I'm glad to share some of the work. I know that here at the ACLU, we've also been litigating cases along the same lines of the work that we've been doing in immigration detention facilities to release people in light of COVID-19, and have filed a number of lawsuits around the country in U.S. Marshals and BOP facilities. One case in particular has gone up, the government has appealed a really good order from the Sixth Circuit up to the Supreme Court last week. The Supreme Court denied certiorari to that petition, allowing it to go forward. It'll go back up probably again soon. But I think unfortunately, I think in the prison and jails context, it's a little bit more challenging to prevail on these types of challenges in terms of release, partly because of the prison PLRA, the Prison Litigation Reform Act, which was passed in 1996, which makes it much more difficult procedurally for prisoners to bring these types of claims. And so those claims have been kicked out because of lack of exhaustions in a number of cases. And so that is particularly difficult. And I think, despite the fact that immigrant detainees and people who are prisoners who are being incarcerated are held in virtually identical conditions, often at times the same facilities, there is a distinction in terms of the legal regimes, which is, I think, bearing down in terms of courts' willingness to actually release people on behalf of COVID. That said, there have been, some important steps forward in terms of improvement in conditions of confinement with respect to COVID-19. But it is by no means, enough to protect people who are imprisoned in both BOP, U.S. Marshals custody, and local prisons and jails, as we know that the death rate is incredibly high in these facilities, as is the infection rate.
Thank you, Eunice. We also, I'm sorry, go ahead, Greg.
Yeah, we also have a case for somebody who was in BOP custody who had an ICE detainer, and we used he got granted compassionate release for the last part of his criminal sentence, and we used the threat posed by COVID-19 to him, given his medical issues, and the fact that he would have been subject to ICE's alternative detention policy or deferral of enforcement actions pursuant to its March 18th order, to get his detainer lifted and to enjoin ICE from arresting him pending his release from criminal custody to serve the remainder of his quarantine period at home. So we've used that, kind of to get people in criminal custody outside of, home and safely sheltered without the transfer to ICE custody and exposure to risk, at that level.
Gabrielle, I just looked up really quickly the question about COVID and public charge, and on the SCOTUS blog, it looks like this did go before the Supreme Court. This was challenged and was actually turned down. So basically right now there's no pause from the Supreme Court for public charge during the pandemic. I don't know if this is from April, the end of April, so I don't know if that's been updated, but as of now, it looks like from this information that there's no pause from public charge even during the pandemic.
Thanks for that, Alan. And I think we'll be getting to our last question here. So Bob is asking if anybody on the panel can discuss how to best present an argument for a temporary restraining order and some strategies for seeking habeas for persons who are not in the high-risk category. And that's kind of a big question, but if anybody would like to tackle any part of that. Okay.
This is Eunice. There have been some cases that we have brought on behalf of people who are not necessarily in the medically vulnerable category. And that has occurred mostly after there has been positive case law in a particular facility and district on behalf, clarifying that the court has jurisdiction to actually release people for these reasons and that conditions in the facility are particularly bad. I think it is a much more difficult argument to bring up a case individually, especially where, a person does not have known, medical risk factors for COVID-19, kind of absent to those conditions. It has happened occasionally, but very rarely. And in the cases where people without medical vulnerability have prevailed in different opinions, it's really been where it's been set up where the court has been amenable to a case that's been brought in kind of a class posture where it's looking at a broader kind of de-densification claim and a depopulation claim. And that's when we've actually seen people successfully released even when they're not part of medically vulnerable category. I think that's kind of the broader analysis that we have had. And I think we've ultimately, in terms of those folks, have been able to succeed in getting those folks released.
This is Sarah from Rapid Defense Network. I would just say in response to that, we actually brought a case very early on in Florida on behalf of an individual detainee who didn't have any underlying medical conditions. There were no positive cases in the detention center where he was detained, but there was certainly plenty of evidence. Thank you to all the doctors who, really spoke out very early on that the storm was coming. And of course, we had a very helpful decision out of the Central District of California by Judge Terry Hatter. I think that particular, issue has always been really important to push. And I think that while the litigation that is focused on the medically vulnerable people is understandable, I think that we also want to continue to make sure we're pushing the legal arguments for everybody in detention, because our health experts have made it clear that COVID-19 interacting with the already systemic problems in a detention center makes it, I forget the exact words that Dr. Allens and Dr. Rich used. I think it was a tinderbox scenario. So I think that it's really important to think very broadly when we're bringing this litigation and not to, and that's what I think all of our litigation, that's not what I think, I know all of our litigation has really tried to focus on.
All right, well, thank you guys so much for taking a stab at that big question. And we'd like to be sort of cognizant of the time. And I think unless Ian has anything else to add, that'll wrap up our questions for now.
Yeah, maybe just one more question. We've focused in this last section about litigation and what folks can do to complement or partner with those litigation efforts. And I wonder, kind of broadening it more and thinking about both advocacy more generally and the expertise that we've heard from in the first panel, if there are other strategies for keeping pressure on immigration detention officials in any of these systems to put pressure for release, whether there are specific avenues for those on the phone or participating, that actions that they can take in addition to supporting the kind of advocacy to promote individual release or support these litigation efforts, at this time. Anyone want to share a little bit about what folks might be doing? think certainly we've seen some efforts to pressure state officials to limit custody transfers from criminal justice authorities or prisons to ICE or immigration authorities. Those are things that people can either put pressure on their governors or legislators by calling their legislators. We've seen some of the groups on the call and others engage congressional oversight entities in Washington. And so folks can be writing to legislators in Washington, asking them to put pressure on ICE and ask them questions. I don't know if any of the panelists have other suggestions, but then we can maybe turn it over. And Catherine, perhaps you might share some final words.
Ian, one thing that pediatricians have been doing has been working with the professional organization, American Academy of Pediatrics, to really push the academy to be writing amicus briefs or just specific letters. Recently, with the binary choice that was given to families in detention, that they can release their children to a sponsor or stay indefinitely as a family together in detention, was just outraged the pediatric world, and a very harsh letter was sent out to DHS on that. And oftentimes they're doing these letters in conjunction with the American Academy of Family Medicine, with AMA, with the American Psychological Association. So I think anyone in the audience who works for professional organizations, it's really important to push that as an advocacy, these issues as advocacy issues for their organization.
Thank you, Dr. Shapiro.
Thank you so much for that, Dr. Shapiro. I've just shared in the chat a PHR e-action, which is sort of an example of the kind of advocacy that Ian was just mentioning. And there's also an active amnesty and PHR state level action in about 10 states, which if my colleague Hajar is here and has links and wants to put into the chat, that would be great. Otherwise, maybe we can email it out. But yeah, I do think that's a really critical way for us to end this webinar today, which is to remember that just as we have medical and legal professionals working together for release, we also have different levels of oversight and authority that we can leverage to ensure that people can be released into safe conditions. So I think this is just the beginning of our conversation, and I know I'll be seeing many of you in future webinars and joint advocacy actions. So I hope we can move forward and use this webinar as just another springboard for joint action. And I really want to thank our panelists, and thank you so much, Cornell, for hosting us and organizing this great webinar.
Thanks, Catherine. Thanks, Physicians for Human Rights, and all of the panelists for your time and expertise. And thanks for those who are participating. And this is a really scary time to have a loved one in detention. We hope that this has been a useful discussion and that some of the resources we've shared could be helpful in relation to your family member or loved one. So thanks, everyone, and have a safe and healthy afternoon or evening.
Thank you.
Thank you very much.
Thank you. Bye, everyone.